Hello, Rodney. How are you? Good. So a quorum being present, the Committee on House Administration will come to order. We want to say good afternoon to everyone. As we begin, I want to note that we're holding this hearing both in person and remotely, and therefore in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. If you are joining remotely, please keep your microphone muted when not speaking to limit background noise, and always keep your camera on. And for those joining us in the hearing room, we're holding this hearing in compliance with the most recent guidance issued by the Office of the Attending Physician. And let me just say, it is a relief to be back in person, and it is wonderful to be here safely with our extra ventilation and without our masks. So with that, I ask unanimous consent that the chair be authorized to declare a recess of the committee at any point, and that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record, and without objection, that is ordered. Now, let me just say, one of the first votes I cast as a brand new member of the House of Representatives, it was late on my very first day in that Congress, was to pass the Congressional Accountability Act. Not a single member of the House of Representatives voted against it. As someone who grew up in a union family and as a former congressional staffer and as a longtime advocate of workers' rights and protections, I was proud to cast that vote, and proud to be part of an institution that sent a strong message to legislative branch employees and the American public by unanimously approving that bill. Less than 2 weeks later, we voted again on a very similar version of the bill sent to the House and Senate. Again, not a single member of the House voted against it. And that version of the bill was signed into law by then-President Bill Clinton. The CAA was a landmark bipartisan reform for the Congress. Until its enactment, Congress was exempt from workplace discrimination laws, and this included, for example, finally extending rights and protections of the Fair Labor Standards Act of 1938 to legislative branch employees. However, one provision of the bill we unanimously approved required additional action. The provision of the CAA that provided for legislative branch employees to organize and collectively bargain as employees in other workplaces can. That part of the law directed the new Office of Compliance, now called the Office of Congressional Workplace Rights, to recommend implementing regulations to the Congress, which, when adopted, would take effect and permit employees to organize. The Office of Compliance did its part. The Office of Compliance carefully reviewed the issue, and after careful review and public notice, the Office's Board of Directors recommended regulations that, as the law said should be the default, followed the substantive regulations already issued by the Federal Labor Relations Authority. But these regulations, as required by the CAA, needed to be approved by Congress before they could be implemented. Our most recent oversight hearing on OCWR on November 19th, 2021, included discussion of the issue of unionization for congressional staff, and during that hearing, Barbara Kamens, a member of the OCWR Board of Directors, testified that, and I quote, "Those regulations were issued by our board 25 years ago, before the current iteration of the board. We've not looked at them, we've not re-examined them, and we have not taken a position on them." Since our November 2021 hearing, there has been increased and significant attention to the issue of unionization of congressional staff and the 1996 regulations from both members, staff, and the press. Accordingly, in continuing our oversight of this issue, I wrote to the OCWR board and asked for their views of the 1996 regulations. The board responded on February 22nd, 2022, and said that following a fresh review of the regulations the board originally recommended, OCWR continues to support them and endorses their adoption. And without objection, I ask that my February 8th, 2022 letter to the OCWR and the board's February 22nd response be inserted into the record. Two important principal goals of the Congressional Accountability Act were to improve the work environment for legislative branch staff and provide them with the same rights and protections afforded to workers in other sectors, and to ensure that Congress operates under the laws it enacts for private sector workplaces. We took important steps forward in a bipartisan basis in passing the original CAA. And we again acted together on a bipartisan basis to add additional reforms, including strengthening protections for staff and increasing accountability for members in recent years, with this committee playing a lead role. However, Congress has still failed to follow through on an important part of the law, and that would provide legislative branch staff with the option to organize, but only if they choose. It's well past time for Congress to follow through on that promise. Today's hearing is an important opportunity to learn more specific aspects of the CAA and Congress's options for moving forward. I would now recognize the ranking member, Mr. Davis, for any opening comments he may have.
Well, thank you, Madam Chair, for holding this hearing on this topic, but I'm just glad that we're back here too. I mean, I feel like you mentioned 1995. We party like it's 1995 here in the hearing room again. Frankly, party like it's February of 2020. I like this. I think this is our way of getting Congress to get back to normal and get back to more bipartisanship. It is refreshing to have the majority talk about this topic before it goes to the floor for a vote, and especially on an issue that is this impactful to our institution. I do want to begin by stating that I believe unions can and do play an important role in helping to facilitate a fair working environment in many industries across America. During my time in Congress, I've been a strong supporter of Davis-Bacon provisions. I have supported union workers throughout my district, including the laborers, the carpenters, the operating engineers, and the mine workers, as well as many others in the building trades and outside the building trades. I've also been a supporter of existing unions here on Capitol Hill in places where they make sense, like the Capitol Police or the Architect of the Capitol, other labor and trade unions. Democrats say they've called this hearing to discuss the status of congressional staff. Considering that they've held the majority for 3 years, this is long overdue as the first hearing of any standing committee to seriously discuss any improvements to Hill staff pay and working conditions. And now that the majority is finally talking about these issues, they're focusing on unworkable, impractical ideas like congressional staff unionization, collective bargaining for people who already have some of the best benefits in the country. Unions do a lot of good to ensure hardworking folks across the country can earn a great middle-class living. But they're simply not feasible for congressional offices. Not only do most congressional staff already have the benefits most unions fight for, voting to unionize congressional offices and committees would create serious problems and lead to even more dysfunction in Washington. Congress's unique office structure, fluctuating partisan balance, unpredictable schedule changes, and unavoidable turnover due to elections make unions impractical in our offices and committees. This is a concept that could create numerous conflicts of interest and impact members' constitutional responsibilities to the American people without the guarantee that any improvements for staff well-being would actually materialize. As a former congressional staffer myself, I understand the unique working situation that all staff face. I know both the incredible opportunities and challenges of being on that side of a congressional office. Like members of Congress, staff are public servants. They are essential to the legislative branch, and our country is fortunate to have the benefit of their unique expertise and skill sets. So we need to set realistic expectations of what unionizing in Congress would accomplish, which is to say very little. First, there is no employment law gap for congressional staff. Second, staff unionization would fail to address one of staffers' main issues, low staff pay. Not only does federal law prevent this, union dues would simply take more from their paychecks without any assurance that improvement to staffers' work environment would come to fruition. Further, congressional staff are all political appointees, not part of the civil service, and unionization would not change that. In other words, collective bargaining would simply add unworkable additional layers without achieving much of anything. Yet, we acknowledge that there's more work that needs to be done to improve staff well-being. Both Chairperson Lofgren and I are members of the Select Committee on the Modernization of Congress. We have had multiple conversations on how to improve the recruitment, treatment, and retention of staff. This committee has implemented several of these recommendations stemming from those conversations. For example, instituting the HR Hub, the one-stop shop for human resource information for the whole House. However, there are more recommendations that this committee should consider. Instead of focusing on those, this hearing is only focusing on one narrow, unworkable pathway rather than all the possible solutions that could directly address the concerns raised by staff. After silence for nearly 30 years on these regulations, OCWR and the outgoing majority want to implement them overnight without appropriate consideration. We need to approach this issue with eyes wide open, have all our questions answered before committing to a course of action. Our staff and this institution deserve better, as do the American people. This committee should focus on regular oversight of these issues and review the recommendations from the Modernization Committee. Unions, again, many whom I've worked with on Capitol Hill and off, in government and outside of government, they play an important role in many workplaces. They just aren't the right answer for congressional offices. I yield back.
The gentleman yields back. Other members are invited to submit any opening statements for the record. I'd now like to welcome our witnesses. Our first witness is John Uhlman, who is the General Counsel for the Office of Congressional Workplace Rights. Mr. Uhlman previously served at OCWR as Acting General Counsel, Deputy General Counsel, and Supervising Attorney. In December of 2015, the Board of Directors appointed him as the General Counsel. In his capacity as the General Counsel, Mr. Uhlman is responsible for investigating and enforcing violations of the labor laws in the CAA, as well as ensuring compliance with health and safety and public access laws that are included in the CAA. Prior to working with the OCWR, Mr. Uhlman prosecuted labor and employment cases before administrative tribunals, trial courts, and courts of appeal for more than 20 years in Milwaukee, Wisconsin. We welcome you, Mr. Uhlman. And our second witness is Mark Strand, who is president of the Congressional Institute. The Institute produces resources such as a House Floor Procedures Manual and a Survival Guide for congressional staff. Mr. Strand has served as president since 2007 and is also an adjunct professor of legislative affairs at George Washington University's Graduate School of Political Management. He's the co-author of the book Surviving Inside Congress. And, like some of us, Mr. Strand is also a former congressional staffer, having spent nearly 24 years on Capitol Hill in both the House and Senate, most recently serving as the Chief of Staff to former Senator Jim Talent. On behalf of the committee, I really want to thank both of our witnesses for their longstanding interest in improving the legislative branch and for being willing to share their thoughts with us today. I would remind the witnesses that their entire written statements will be made part of the record, and we would ask that you confine your oral testimony to about 5 minutes. So first, Mr. Uhlman, we're happy to recognize you. Could you pull the microphone just a little bit closer? Help you. There we go.
All right.
Much better.
Okay. Thank you for this opportunity to speak with you today about implementing the rights of congressional staff to collectively bargain under Section 220 of the Congressional Accountability Act. As you know, I'm the General Counsel of the Office of Congressional Workplace Rights, and under the CAA, I have specific statutory responsibilities with respect to Section 220. I know that many of you have questions about today's topic, so I will keep my oral statement brief. Prior to the hearing, I did provide the committee with a detailed written statement and a document from my office containing answers to frequently asked questions about unionization and collective bargaining. In my written statement, I tried to provide you with 3 types of information concerning the past, the present, and the possible future if a resolution approving the OCWR regulations is passed by the House. Regarding the past, I provided some background information about the regulations approved by the board in 1996, how lack of congressional approval of these regulations affects the collective bargaining rights of congressional staff under Section 220, and how the current board responded to the chairperson's recent inquiry as to whether the 1996 regulations are still being recommended for approval, given the changes made to the CAA in the Reform Act. As you know, the members are now unanimous in recommending that the regulations adopted by the 1996 board be approved by Congress. The statutory procedures under Section 220 were not changed by the Reform Act, and the regulations are not obsolete because of changes in the House or the Senate since 1996. Regarding the present, I noted the pending approval resolution now before this committee and suggested some steps the committee might take regarding the language. I also provided a brief explanation about how unionization and collective bargaining currently operate under the OCWR regulations that were approved and issued in 1996 and which apply to other staff in the legislative branch, since these are the same regulations that would apply to congressional staff if the House were to approve the pending regulations that the board has not yet been able to issue. These regulations contain procedures that are able to resolve representation questions, such as who must be included or excluded from a bargaining unit, as well as negotiability and all other issues. Finally, regarding the future, I tried to answer some of the big picture questions about how unionization and collective bargaining might work if the rights of congressional staff would be implemented in the House. Because the definition of employing office in the CAA, and because most decisions regarding staff working conditions are made by the management of each member office, unions would have to organize at the member and committee office level. There cannot be one bargaining unit for most House employees because the House of Representatives itself is not an employing office. On the other hand, it would be possible to have more than one bargaining unit in an employing office. For example, committees would likely have 2 bargaining units, which would be split by party affiliation. Since I have noticed a change in the type of questions I have been receiving in the last few days, I also want to talk briefly about the duty to bargain under the Federal Service Labor Management Relations Statute, most of which is incorporated into Section 220. For convenience, I'm going to refer to this as the statute. The duty to bargain is very limited under the statute. It is nothing like what exists in the private sector under the National Labor Relations Act. When we talk about the duty to bargain, we are talking about proposals made by a union that management must bargain over. Under the statute, the only mandatory subject of bargaining is over conditions of employment, which is defined in the statute as personnel practices, policies, and matters, whether established by rule, regulation, or otherwise, affecting working conditions. And that's in Section 7103A14. In addition, there is a broad prohibition against proposals contrary to law and a very expansive definition of management rights in Section 716A that prevents mandatory bargaining on any proposal that would keep management or severely restrict management's right to do such things as determining its mission, budget, organization, number of employees, internal security, hiring and firing, disciplining, and making job assignments. So many of the bread and butter issues that labor unions can compel management to bargain over in the private sector are usually off the table for federal employees under this statute. The union can, under certain circumstances, compel bargaining over procedures which management will use when exercising a management right, or appropriate arrangements for employees adversely affected by the exercise of a management right, but this is a far more limited form of bargaining than what exists in the private sector.
Thank you, Mr. Ullman. Your time has expired, but your full written report is available. It will be on our website not only for the members, but for staff and other interested members of the public to thoroughly review, and we do appreciate it, and we will hold you available for questions after we hear from Mr. Strand, who will now be recognized remotely. Mr. Strand?
Thank you, Chair Lofgren and Ranking Member Davis and other members of the committee. Thank you for inviting me to testify on the issue of congressional staff unionization. I believe unionizing would ultimately harm Congress and inhibit the work of elected representatives and threaten their independence. I want to make clear, though, that I'm not against labor unions. I'm the son of a union shop steward, and as a former staffer who served in the House and Senate for 24 years, I am mindful of the often challenging circumstances of being a congressional employee. My written testimony contains a lot of open-ended questions that need to be answered before taking a single step towards allowing employee unions among your staff. Because once you start down this road, you might find it extremely difficult to turn back. For the first 100 years of our government, Congress didn't have staff. It wasn't until a joint committee in the 1970s pushed through a number of reforms that modernized Congress that we arrived at the current number of staffers working for individual members. I mention this because citizens do not elect staff. They elect a single individual to represent them. Members then are given broad latitude to hire the staff they think will best serve their constituents. The executive branch currently has more than 2 million employees, plus 4,000 political appointees, all of whom help the president execute his agenda. For Congress to compete, it requires strong individual legislators. We empower members to organize their offices based on the unique needs of their district. The independence of each individual member is a key to Article I powers invested in the legislative branch to our Constitution. Our system of government was intentionally created to invest significant power in individual lawmakers. By contrast, the political parties in a parliamentary system control most staff, which serves as a check against individual members, showing independence from party leaders. To give up that kind of independence that is ingrained in our system would put Congress at an even greater disadvantage against the executive branch. The essential problem with unionization is that the union will share control over terms and conditions of employment with the elected representative that intersect at vital points with the ability of a member to represent his constituents. The classic example is the right to discharge an employee. A lawmaker hires a legislative aide to assist with that member's primary committee assignment. The aide performs adequately on most issues, but develops a contentious relationship with committee staff, which in turn threatens the member's ability to participate in the committee process. Is there a just cause to discharge the employee and hire someone who can get along with the committee staff and thereby ensure the member's legislative agenda is achieved? How do you prove that in some kind of grievance procedure? Do you get affidavits from committee staff? What if, while that process is going on, the committee is passing a comprehensive reauthorization that won't occur again for another 10 years? How will the member explain to voters that internal staff disputes led to legislative failures, but that member still deserves to be reelected? What if the staff member performs their job functions well enough, but makes a very poor impression on constituents, like a front desk person who has difficulty making people feel welcome? What if the scheduler makes periodic mistakes that embarrass the office with double booking meetings or not factoring in travel times in the district? How many mistakes are enough to justify replacement? Unionization would require uniform jobs in each office, ultimately, which would take an incredible amount of agency away from lawmakers. Right now, a staff assistant in one office might also be a press assistant, but in another, she oversees interns or handles one or two smaller policy issues. How would standardizing the job of a staff assistant help young employees learn the other roles needed in Capitol Hill office? A union, under the guise of improving workplace conditions, might enforce labor hours, but congressional committee schedules can vary from week to week, even day to day. Washington staff can put in long hours during session, but during recess periods, it's a district staff who's no longer working traditional 9 to 5 and instead staffing their boss at breakfast, dinners, and weekend events. These are the normal feast or famine hours of congressional staff. But if union decides that such long hours are detrimental, what happens then? How is a member sufficiently served when someone other than she and the chief of staff determine when employees can work within reasonable limits? What happens to a committee if a markup runs long or extends into the morning hours? Are time-sensitive negotiations put on hold because staff must remain off the job for certain periods to comply with union mandates? Senator Robert Byrd, a supporter of unions, spoke against Capitol Hill and unions. He said senators will no longer have the ability to structure and manage their staffs consistent with the unique needs of the states which they represent without first consulting with union representatives. Congressional staffers, just like members, feel pulled to public service. Working conditions can certainly be improved, but the correct approach is robust oversight through this committee, or even by looking at what your colleagues on the Committee to Modernize Congress have done. Discretion over things like salary levels, job responsibility titles, hours to a reasonable extent, among a myriad other issues, need to be left to the members themselves. Thank you for inviting me to testify.
Thank you very much, Mr. Strand. And now is the time when members of the committee can ask questions for as long as 5 minutes. And I'll turn first to the ranking member, Mr. Davis, for his questions.
Thank you, Madam Chair. Mr. Strand, I appreciate you being our witness today, and great to see you again. You mentioned in your testimony, did I hear you correctly, that former Senator Byrd from West Virginia did not support unionizing congressional employees because of the unique office type of experience?
Yeah, that's correct. And of course, Senator Byrd was a strong supporter of unions in West Virginia.
Yeah, that's what I was going to ask you. Has he ever been accused of being
Yeah.
anti-union?
No. But he just didn't think it would work on Capitol Hill. And the reason for that is, you know, he was a great institutionalist of Congress. And what he said was that they'll no longer have the ability to structure and manage their staff consistent with the unique needs of their states. Because this is a unique relationship. When you're elected by the voters, they elect you. And whenever you invite somebody else into that process of how you're representative, whether it's staff or a union representative or someone else, you're necessarily getting in between the member and their constituents. And this is it's a dangerous place to be, because it's already, it undermines the ability of members to do the job the way they think it's best for their district.
And former Senator Byrd, who had some other unique historical perspectives, felt this way, that it would could impact the legislative process, and also maybe disrupt the congressional process that we follow here in the House. Do you agree?
Yeah, and I think I think he agreed with that statement. And I agree with your assessment there. The biggest challenge continually is that, what is the leverage that unions would have? Auto workers make automobiles, and so their leverage is to stop making automobiles in a strike. Legislative staff make legislation. Caseworkers do casework. Staff assistants perform constituent services. And these are all but they don't do them independently. They do them at the express direction of the member of Congress who hires them. And so once you invite somebody else into that process, there's multiple influences generating how they perform their duties serving the constituents. And this is where the problem comes for the independence of individual members of Congress.
Well, listen, I know you mentioned the Committee on Modernization, Subcommittee on Modernization of Congress, and recommendations. I think you and I both agree that some of those recommendations ought to be discussed at this committee's level. So I appreciate your time today, Mark. It's great to see you again. Give my best to your family, too. Mr. Uhlman, was very impressed with your resume until I saw that you actually went to a law school to let my colleague, Mr. Stile, in. So a little lower there, knowing that you both went to the University of Wisconsin-Madison Law School. No, I will not yield, Mr. Stile. In a letter from February 22nd of 2022 from Barbara Childs Wallace to Chairperson Lofgren, she stated that the board urges Congress to approve these regulations. Do you think it's the proper role for OCWR to advocate for the adoption of certain policies?
Well, I think it's the position of the board that the policies have already been decided by the Congressional Accountability Act. I mean, I think it's Congress's role to determine the policy. And the Congressional Accountability Act clearly provides that these rights exist for employees, and it's just a technicality that they haven't been implemented for congressional staff. So, I mean, if Congress does not believe that unionization is something good for Congress, they should pass legislation that says that. And I don't think the CAA says that. So.
Has OCWR crafted a handbook or guidance on the organization and management of unions in the House of Representatives?
Well, it's going to be a challenge.
So the answer is no?
No. I mean, I think we had a challenge with the Reform Act, and we met that challenge. And I think the same thing would be true with this effort, and again, it's very hard to predict exactly, how many petitions we're going to get. I mean, it's still extremely going to be extremely difficult for a union to organize, and it's going to be even more difficult to get a collective bargaining agreement. So,
Well, I got another question. My time's running short. I apologize, Mr. Ullman. It was announced during an OCWR-hosted brown bag lunch last week that your office is compiling a resource of frequently asked questions. Is this correct?
yes, in fact, it's up on our website. Yes.
All right. It's just inexcusable that the only guidance your office is offering is FAQs. It's clear that there are a lot of unknowns and that your office hasn't provided the necessary information for staff and employing authorities alike for them to fully understand the impacts of what we're discussing today. So with that, Madam Chair, I'm out of time. I yield back.
And yields back. I believe that Mr. Raskin is joining us remotely. I would recognize Mr. Raskin if that is correct. Mr. Raskin is not appearing on our screen, so I will turn to Mr. Aguilar, who is also, I understand, participating remotely. Mr. Aguilar would be recognized. Oh, apparently Mr. Raskin was trying to log on, so we'll go back to Mr. Raskin to recognize him remotely. Mr. Raskin? Apparently he's lost the feed, so we will go to Ms. Scanlon, who is here in person for her questions, and hopefully the two remote members who they noted, both of them publicly, have tested positive for COVID and have to participate remotely will be able to reconnect. Ms. Scanlon.
Thank you, Chair Lofgren, for holding this important hearing, and thank you to our witnesses for being here. You know, obviously, this is a topic of intense interest, both on the Hill and off, and I really welcome the opportunity to dig into this a little bit. You know, I've worked for many years in the legal services field, and many of the arguments we're hearing here are similar to the arguments that we heard when legal services lawyers tried to organize. But also there are many of the same reasons why legal services lawyers tried to organize. If you look at their union, you know, as they started talking to each other, they found out that they had widely shared concerns. Resources were problematic. People, workers from around the country found that their working conditions weren't great. There were problems with hours and treatment and those kind of things. Some of the things we see right here in Congress where, as has been mentioned, the working conditions are not always ideal. So I do welcome the opportunity to talk about what are the barriers to unionization so that they can be addressed, and what can we do to make it easier. I too have served on the committee, the Select Committee to Modernize Congress, and we've had many, many discussions about things that need to be done to make life on the Hill more livable for everyone. I was really interested in reading in the May 23rd, 1996 Congressional Record, there was debate about staff unionization efforts that could not include pay, health insurance, or retirement benefits. These are typically things that people negotiate with through their unions. So can you talk a little bit about that, just so it's clear to people?
Sure. I mean, and that was the point I was trying to make about how limited both the duty to bargain is, as well as the scope of bargaining is under the statute. So really what I would call the bread and butter issues, you know, really cannot be bargained under the statute because they're usually determined by law, or they're would be infringe upon a management right. So.
And can you compare or contrast that to how other federal employees are treated?
I mean, that's really the same. I mean,
Okay.
it's really, you know, there may be more opportunity in Congress simply because there are less laws that regulate, you know, some of these areas. You know, so, and that, you know, those opportunities would probably have to be decided by the board, you know, by a petition. But for the most part, those are the same restrictions that are on all other federal employees, so.
So what do you see as the greatest impediments to unionization that would need to be addressed?
Well, you know, and I'm not sure some of them can be addressed. I mean, you know, as I said, unions would have to organize on the member level, you know, so you can't have one member for, you know, one bargaining unit for everybody in Congress. Now, there are ways that you can collectively bargain with multiple employers. And so, you know, if a union was able to organize multiple offices and the management of those offices agreed to bargain collectively with the union, you could come up with either a master agreement or a lead agreement that would apply to all of the offices. So, I mean, that, you know, that's something that management would have to decide, and that would be something where the union would have to, you know, be able to, one union would have to be able to, you know, organize multiple offices, so.
So that would be similar to implementing model employment rules.
Sure. I mean,
offices.
This is something like, for instance, that happens a lot in the construction industry where you have multiple small employers. So there's a master agreement that all of them have signed on to.
Right.
You know, so.
Okay. It's just really interesting to tease it out, especially this idea that it would have to be office by office. So if we can only have 16 employees, some of whom are part-time, whatever, those are pretty small units, but there could be a greater collective bargaining space. I mean, I'm very interested in the organization movement. I mean, I represent Southeastern Pennsylvania. That is union country like no other, and it has served our country well. It has built the middle class, and we've seen how the rollback of the ability to organize and collectively bargain has really hurt our middle class, and I'm really, really heartened by the fact that we're seeing a resurgence in interest in organizing around the country in places where people previously said it wasn't possible, like legal services, although that's existed for a while, like Starbucks, for example. So I am interested in teasing out what we can do in this area, so thank you.
Gentlelady yields. The gentleman from Georgia is recognized.
Well, thank you, Madam Chairman. Appreciate the opportunity to be here today. And, you know, this is an important issue, and it's important that we discuss these issues. I think this is a solution looking for a problem. But still, an idea is an idea, and we have to look at me. Recently on another committee I'm on, we took on a nonsensical idea of the post office becoming a bank. So as we went through the process, we realized, I think everybody realized that was not a good idea. But I think we do need to look at this. But there's several pitfalls that unionization would have and I agree with Senator Byrd, the uniqueness of this institution requires flexibility. It requires each individual office to meet the unique needs of its constituency. It's not just state by state, it's district by district. A homogeneous type of operation, I think, would create many more problems, and those who would suffer from that would be the constituency of the people in America. I mean, I even think back of what happens when the staffers decide to go on strike right at the end of a government shutdown and we can't really function here. I mean, these are the types of things that, you're crazy. Well, you know, there's crazier things that have happened in the world, and we have to think through these. And my office is very transitional, you may say, in the way that we have operated. My staff and what they do now is different than the staff that I had when I first came in. I've made up positions to meet the unique needs of our district. As Georgia's economy has grown, even after the pandemic, we have grown substantially. Many, many more new businesses are coming into the state, so I created a staff position for someone to go and just introduce themselves to new businesses and new organizations to let them know how we can represent them and work with them. And so the duties in my office is based on the strength, the talent, and the interest of each staff member. I have at one time I had a scheduler here and a scheduler in the district. My scheduler in the district also took on other duties when I was up here. I may have a legislative correspondent who also works as a staff assistant, or I have one right now that's an LC and is working as an LA because they have an interest there, but they still like doing the legislative correspondent work. So we actually look at the interest and the talent of every member, and we know how to best operate our office, and we transition as we need to. So, Mr. Strand, we are more, unions appear to be more effective. Now I'm in a right-to-work state of Georgia. The unions we have in Georgia are predominantly in larger businesses, larger construction companies, larger industries. You very rarely find unionization in the small businesses because, quite frankly, the employees don't want to be unionized. And the uniqueness of each small business is they have to have the flexibility within their staff. The makeup of Congress, because of the way the MRA is done, the way that we do our own hiring, is we operate more as individual small businesses. So, Mr. Strand, the independence of each individual member is key to the Article I powers invested in the legislative branch. Can you elaborate on that and what some of the pitfalls of a homogeneous type operation would be?
Thank you, sir. I think that it goes back to the whole central issue that if you have another interest negotiating the terms and the control in terms of conditions of employment, besides yourself, the voters are getting someone they didn't vote for. And this is the challenge continued, is that I do staff retreats all over, and every office is different. Every member has their own unique needs in their districts. They do things differently, from outreach to casework to the legislative staff and setup. And so the uniqueness of the office is based on your unique relationship with the voters. And this is why I think it's just not practical to do it, especially on this office by office level. I'm not sure how that would work on a practical basis. Now, this is not to say there aren't bad employers up there, but the key thing is that I think most members recognize that other than their own time, their most precious resource is their staff. And you can exponentially increase your influence and your ability to do the job. You have good management and good staff. And that's something you can't change through a union. That's something that you have to do as members.
All right, thank you. We could go on this all day, but I see I'm out of time. And you're right. This is a unique employment. This is not generally a career path for people who work here. I've got folks in this room that used to work in my office and moved on to other things. Hopefully they enjoyed our time there, but still, there are bad employers, and that's something that has to be dealt with individually. With that, Madam Chair, I yield back.
The gentleman yields back. I understand the technical difficulties have been resolved, and Mr. Raskin is now recognized for 5 minutes. Mr. Raskin. Well, apparently I was, there he is. Mr. Raskin, you're recognized.
Thank you very much, Madam Chair. All employers are unique in his or her or its own way. The history of the labor movement, of course, is confronting employers who say, we're different, we're unique, and we take care of our people, and we're sensitive to the needs of our employees and so on. And so I think we've got to take that with a grain of salt. Well, what is unique about our situation is the point that I think Mr. Strand and the ranking member made, which is that we are the Congress of the United States, and we have to get the job of lawmaking done. Having said that, under Article 1, we have the power to pass all laws necessary and proper to the functioning of our institution. And so we can design it the way we think we need to design it in order both to vindicate the interest of staff to having a fair workplace where their interests are recognized and taken into account, as well as the paramount interest of the government in legislation. And I think we can do both. So, Mr. Uhlman, let me come to you. First of all, does the right to organize exist now in the staffers? In other words, is there anything that would stop under the First Amendment and under this legislation already passed, workers, staff members in a particular committee or particular office getting together, meeting, caucusing, and then saying they want to present the member with requests or demands of some kind?
Well, that's a difficult question. I mean, yes, certainly they can do that. The problem is they probably could not enforce any type of agreement they reached through our procedures, I mean, through the OCWR, so.
And that's the necessity of action right now. But theoretically, the right of them to get together exists. And after all, Section 7 of the National Labor Relations Act itself was based on the First Amendment and the idea of people having the right to speak, to assemble, to associate, and get together. And that's really all we're talking about doing, is vindicating that right. But there are particular complexities that are attendant to the legislative function of the national government. So help us with this. What exactly is the bargaining unit? Is it each member's office? Is it each committee's office? Or is it, I could contemplate a situation where it's all the press secretaries from all the offices? Is it the Democratic and Republican and independent members together? Or is it each separate? Is that going to be defined by regulation by us, or is that going to be defined through a kind of common law process of considering collective bargaining agreements and attempts to organize?
Well, I think the question you're asking is really what we call the appropriateness of the bargaining unit. So the way the process works is a union would propose a bargaining unit. And if there was a disagreement with management regarding the appropriateness of that unit, they would then use the OCWR procedures to resolve that disagreement. Generally, I mean, a bargaining unit has to be composed of members of the same employer. So I think that you can't have a bargaining unit representing, from multiple employers. As I said, there may be opportunities after you form the union to bargain, jointly, but from an organizing perspective, I think it has to be from each employing office.
Okay, and here you're defining an employer as a member, is that right? Or a committee or subcommittee?
Yeah, the problem is the CAA says an employing office, is not the House of Representatives. It's each office of a member or each committee office. So.
Okay, good. All right. So I think what probably gives everybody pause on this is the nightmare scenario invoked by some of our colleagues, which is, what happens if we face some kind of massive strike or shutdown in the middle of the appropriations period or something like that. I know that there are public sector workers who have the right to organize, but not, for example, the right to strike. I think that works that way with a lot of teachers and other public employees. Is that something that will be determined along the way, or is that something that will be built into the legislation that we're considering right now?
Yeah, the statute itself actually, totally prohibits both strikes and lockouts. So that really isn't an issue. It's never been an issue with federal employees. So.
The gentleman's time has expired.
Madam Chair, thank you. Could I ask unanimous consent to insert a statement by our colleague Andy Levin from Michigan?
Of course, without objection. Mr. Stile is recognized.
Thank you very much, Madam Chair. Mr. Ullman, appreciate you being here. It's good to see a fellow Badger alum, despite what Ranking Member Davis says. It's good to have you here. I want to discuss with you the process of developing the regulations. I know your team recently went through a pretty expedited review of the draft regulations from the 1990s. And to my knowledge, had no edits. Is that correct?
Excuse me, I didn't hear the question.
You reviewed the draft regulations that were produced in the 1990s with your team, and you had no additional edits?
The board did review the 1996 regulations that were adopted by the 1996 board. So yes.
So there were no recommended changes or edits to that regulation. Is that accurate?
Right. That's correct.
And can you explain the process of the review that your team went through when reviewing these regulations?
Well, again, they went through the notice of adoption is very detailed. It went through all the comments and the 1996 board's response to the comments. They reviewed kind of the dissenting views and determined that, and really the regulations themselves, all they say is that the regulations that apply to everybody else are going to apply to Congress. And so so, we've had those regulations in place since 1996.
And how many days total did that process take, Mr. Ullman?
Well, it's the date between the two letters. I mean, I pretty much began when we received the letter and ended, I believe, on the date that that the board sent the letters.
Do you recall what those dates were? Just how many days that might have been?
Offhand, if I could look.
A handful of days? Weeks, months?
It was 20 days. I think it was around there.
A couple weeks. Okay, well, maybe we can get that for the record later. And then following that process, you sent the regulations to the board for their approval. Is that accurate?
Again, the regulations, the way it works is the regulations are published in the congressional record once they're adopted by the board. So those regulations are still there. I mean, we did send another copy to the chairperson, but those regulations have already been published and have been out there since 1996.
And obviously, a lot has changed since 1996. I think there's a lot of staffers on the Hill that probably weren't born at that time. Have you considered whether or not it would be necessary or appropriate to have an additional notice and comment period since it's approaching 25, 30 years since it was initially drafted?
Just so we're clear, it isn't. This is the decision of the board. That's not my decision to make.
Understood, but in your opinion, would that be a helpful process or a not necessary process?
Well, unless they're going to change what they proposed in 1996, there's no purpose.
You don't see a need for it. Okay. Committee staff in both the House and the Senate requested to see copies, I think, of the original comments that were made during the initial notice and comment period. But I believe your office stated that those no longer exist. Is that accurate?
No, I think, but there were 3 comments. I think the comments are fully described in the notice of adoption. I think the actual letters, I think we found 3 out of the 6. So I think we're still looking for the other 3.
So a slightly incomplete record. It would be at least my analysis of it. Have you considered kind of the potential conflict of interest congressional unions may create with their members? And let me put a pin on this. In your comments, I believe, to my colleague, Ms. Scanlon, you noted that a bargaining unit could exist with more than one member. Is that piece accurate?
No.
It would be one member to one bargaining unit?
Each member office would have to have a separate bargaining unit.
So you couldn't have a group of members come together into one cohesive bargaining unit under your understanding?
I don't believe that's possible under the CAA.
Okay, very good. And then would a committee staff, would that bargaining unit be a minority and a majority staff, or would that be all under the chair of any given committee?
I think, as I indicated, I think that would have to be split along partisan lines. So because the ranking member determines for the minority and the chairperson determines the working conditions.
Even though the employing authority might be just the chair on a committee.
Right, but an employing office can have more than one bargaining unit. I mean, we have multiple bargaining units
Okay. So. And do you see a conflict that would exist if the Senate and the House chose different paths?
A different path?
Different path if the House chose to unionize and the Senate did not, or the Senate chose to unionize and the House did not?
Well, the CAA allows that. I mean, since it can be adopted by a one-house resolution, so at least the act itself contemplated that where one house would adopt regulations and the other wouldn't. So.
Thank you very much. I appreciate your testimony today. Madam Chair, I yield back.
Gentleman yields back. Mr. Aguilar, we'll see if our technology is working, and can we recognize you?
Madam Chair, can you hear me?
We can hear you, but we can't see you.
Well, I assure you I'm around. We'll see if they can switch.
There you are.
There we go. There we go. Thank you, Madam Chair. Appreciate the importance of this hearing. And Mr. Ullman, I'll get to you. According to the OCWR, when employees file a petition to eventually be certified as an official bargaining unit, the petition, I want to get this right, must have the signatures of 30% of the employees. Is that what you testified?
Yes, there has to be a showing of interest by 30% of the employees in the bargaining unit.
Our colleague from Georgia talked about the need for transitional. So let's go with that. And knowing that some of our offices are small, the bargaining units could be comprised of 2 or 3 staffers. And if an individual leaves a bargaining unit, how does that change a union? in an individual office? Is the union still legal? What if all the employees covered in the bargaining unit leave their positions over the course of the congressional term? What would happen in that case?
Excuse me, I didn't catch the end of that.
What if the employees covered in the bargaining unit, let's just say that it's a bargaining unit of 4 people. What if there's a transition and over the course of the 2-year cycle in Congress, all of those employees end up moving on to other positions? So what would happen in that case?
Generally the way, union collective bargaining agreements operate is that, once the agreement is in place, it really, it's in place for those positions. And so it doesn't matter whether the actual people in those positions has changed.
Okay, I appreciate that. In your testimony, I wanted to get a little deeper into the membership and management piece. You noted that management officials are, and I'm quoting here, those employees whose duties and responsibilities require or authorize the individual to formulate, determine, or influence the policies of the employing office. Can you tell us a little bit more about what kind of staffers would be considered management?
Well, generally, management are those staffers who determine the conditions of employment. The idea is to separate those staffers who are going to be on one side of the table from those who are going to be on the other side of the table. So if you're going to bargain, you're going to bargain with the people who are determining the terms and conditions of the employment. So that's really the dividing line.
So it doesn't have to do specifically with supervisory responsibilities and roles?
Well,
I think that's just an area of confusion.
Yeah, I mean, as I said, that's how you divide it. So whatever you call the position, the question is whether or not this is a position that is deciding, what the rules of the office are going to be, or is this, someone on the other side, who is being subjected to those, those procedures. So.
Yeah, no, I understand that. I just think from the perspective of an employee, it oftentimes, might feel like management is whoever is supervising you. So if you're an intern, your supervisor is a staff assistant potentially. If you're a staff assistant, your supervisor might be the chief of staff or deputy chief of staff. So I just think that there's some confusion in that sense that we might need to clear up. House committees also have nuanced management structures. How would the committee staffers fit in that respects on the management side? Is it still the same answer?
Yeah, again, it would be, who in the committee is deciding what the conditions of employment are. So it would undoubtedly be, the senior staff.
But do you have any more guidance on what that definition of senior staff might be?
Again, some of these questions obviously can be tricky. Which is why we have procedures in place to determine, if somebody should be included or excluded from a bargaining unit. There is a difference between what we would call a lead worker position and somebody who's really in management. So somebody who merely is giving direction for work, but doesn't really have a role in determining the conditions of employment is not going to be considered management. So, so.
I appreciate that. My time is running short, so I will yield back, Madam Chair.
Gentleman yields back, and the gentlelady from New Mexico is recognized.
Thank you so much, Madam Chair, and for our witnesses for shedding light on this issue. In the 14 months I've been here, I truly admire our staffers. They are committed to this institution. They're committed to their jobs, and I think them speaking out about this now is a good thing. And it strikes me, listening to the testimony and reading it, that the CAA was adopted, as was pointed out, decades ago, and it was in the Congressional Accountability Act that actually set up the process for this unionization. So Congress already did this. And it also strikes me, sitting here today after that great State of the Union address last night, that President Biden said, When we invest in our workers, we can do something we haven't done in a long time, build a better America. And I think if we apply that principle everywhere, we would want to apply it here as well, so we can build a better Congress to better serve our constituents, because that is indeed what we are trying to do. So in looking at this, Mr. Strand, you have spent decades committed to this institution and committed to making sure that the workplace works for different people in these offices. Do you think that when we strengthen our staff's working conditions and pay, we also strengthen Congress's capacity, especially increasing our capacity as a co-equal branch of government? Yes or no?
No, I think that the conditions of workplace for employees makes a huge difference in the ability of staffers to serve the country, just like the members of Congress. The biggest thing you have to have is that that's the responsibility of the member.
Well, I was asking whether you believe that strengthening the employees was a good thing, and I think you have indeed said
Oh,
yes.
I absolutely
So
agree with you.
Thank you so very much.
thank you.
You know, my district is the size of Pennsylvania, and so I have staffers that are, sent out over a very large area. I want to make sure that they work at a job that they love, but that they are able to stay at it if they so desire. Mr. Ullman, you described the unionization process in detail. Mr. Strand earlier expressed his concern about a union preventing staff from working long hours or changing the at-will nature or changing some of the things that are already in the Congressional Accountability Act. Could you just clarify, if a office chooses to unionize, could they change the provisions of the Congressional Accountability Act that says at-will strikes are not allowed, those other matters that he pointed to?
No.
But if, can you point to examples from other unions on the Hill that might account for varied responsibilities, different working hours? I mean, there are, I could imagine, quite a few unions that are dealing with complex working conditions. Is that correct?
Sure. I mean, we have, I think, 20-some bargaining units on the Hill. I think the largest one is the Capitol Police. So they provide, a lot of complex tasks and then happily they just entered into another agreement. So after many years of bargaining, so.
Well, that is a good thing, right? And I believe that what we're looking at here is the fact that we are now hearing from our staffers about these issues, and that if we want to invest in our staff and we want to be able to listen to our staff, would you describe a unionization process and a union as a way of increasing management's ability to listen to the issues that affect those workers?
I mean, certainly. I mean, anytime you sit at the table together to discuss working conditions, each party is going to learn a little bit more about the other. I mean, labor is going to have a better idea what the challenges are of management, and management is going to have a much better understanding of what the real concerns are of labor. So even if you don't get a collective bargaining, even if you don't get an agreement, if you sit down and discuss it, I mean, you're likely to have a better understanding of where the other party sits. I mean, so.
Yes, indeed. This concept of actually listening is a wonderful thing to do, and we all are committed to doing that with our constituents. And this would give us an opportunity, not an opportunity, but an obligation to sit and listen to our staffers. With that, Madam Chair, my time has expired, and I yield back.
Gentlelady yields back. I have just a couple of final questions. First, as you have mentioned, Mr. Ullman, the issues that can be bargained is fairly small compared to what you would have under the National Labor Relations Act: pay, health insurance, retirement benefits. Some have asked the question, what about when dramatic changes need to happen quickly? For example, because of the pandemic, the attending physician's office told work remote. We did, we changed on on a moment's notice to remote for health reasons, telework, masking, social distancing, hybrid work arrangements, office cleaning, and the like. Would those changes be subject to collective bargaining or not?
Again, that may be a difficult question to answer, but what I can point out is that there is, an exception for emergency situations, so that, generally in an emergency, management can act very quickly, and even it might mean that bargaining might be very expeditious, and it might be a call to the union saying, this is what we're going to do. We have to do it. It's emergency, But there is a provision in the statute that does allow for kind of very prompt action by management during emergencies. So,
Let me ask you, and we've had occasions where a member dies in office and the clerk maintains the office staff until the election provides a successor. What would happen in that instance where the clerk is running the office and that was unionized? How would that work?
yeah, and I'm not sure I have a clear answer for that, I'll be honest with you. I think, what we would have to look at would be kind of successor type cases, and try to apply that's, similar type of analogy. So, in many cases, with a corporation, for instance, if there's a change, that doesn't necessarily mean that the collective bargaining agreement goes away. So,
Okay. If there's a dispute between a member and the union and the member, and then that member leaves the office, what happens to this dispute and the bargaining unit in that case? How would you resolve that?
Well, I think that again, if there is a collective bargaining agreement, there probably is a grievance procedure in place. And if for some reason, management or the clerk, if that's would refuse to use that bargaining unit, then it could be resolved through the unfair labor practice procedure. So, there are procedures that would resolve that issue. So,
Would it be assumed, since none of us are entitled to this job until reelected, that the terms of the agreement would be renegotiated after every election, or would it be a continuing agreement, do you think?
Again, I'm not sure. If the same office holder is there and the office is the same, it may be a possibility to continue the agreement, into the next term. Obviously, if a member is defeated, then the office changes. And,
Right.
So.
Well, I just think those are outlier situations and should not dominate any decision-making, but I hope that we can think through some of the odd cases that might come up, make sure we know what the answers are, and accordingly, the hearing record will be open for 5 days. If members of the committee have additional questions for either of our witnesses, we will send them to you, and certainly ask that you respond as best you can, so that we can make both the questions and the answers part of the written record. I just want to thank the witnesses and the committee members for their attention today. It has been mentioned that we had unanimity. I think I'm the only member here who was a member of Congress in 1995. This was unanimous. We had 2 votes in the House. The first was 429-0, and the second was 390-0, and it included those measures, unionization for the staff. I'll just mention, in 1998, one observer wrote this is a quote: "The Office of Compliance drafted regulations implementing this section, which concerns the unionization of legislative employees, but Congress has not approved them. This is a disgrace to the principles supporting the CAA." He continued, "The result is that no regulations are in effect, and this section of the Act is not being implemented." Who said that? Senator Chuck Grassley. And I would ask, without objection, that Senator Grassley's Law Review article from the Harvard Journal on Legislation from the winter of 1998, where he made that observation be included in the record. I also would ask unanimous consent that the following items be made part of the record: an August 11th, 1994 Washington Post article, a January 9th, 1995 New York Times article, and May 2nd, 1995 Congressional Research Service report, a January 1, 2011 Office of Compliance publication, labor representation, collective bargaining rights in the congressional workplace, a March 2nd, 2022 written statement of Daniel Schuman, the Policy Director for Demand Progress. I think we have additional thinking to do on this, but I think that this very helpful hearing has helped us focus on the few remaining nuanced issues that need answers. I would just note that we all value our staff. This institution could not run without our staff. And I was thinking, I recently had my district director, only my second, who retired after 22 years in my district office. And as we were celebrating her years of service, another member of my district office staff mentioned that she's been working for me since 1987 in both my local office and now in the congressional office. So we go back a long ways with these valuable people who do the people's business, and their rights need to be respected and considered as was envisioned by those unanimous votes my freshman year in Congress. So unless there are further issues before us, we will thank the witnesses and the members and adjourn this hearing.